Part heard of you on the matter of the Queen of the application of United Trade Action Group Ltd on Transport for London and
Yes, Mr. Colvin. Please take up the invitation, certainly. Yes.
Yesterday, the appellant argued that the driver telling the operator where he or she is, so that the operator can convey information to a customer of the app that there's a vehicle or vehicles in their vicinity applying for hire. And in discussion, he said it was applying because it was active conduct on behalf of the driver. And then this approach then led him to say that the display of the operator's telephone number on the side of the PHV was active conduct and therefore also counted as applying. With respect, this was a novel and bold submission, as I said at the outset yesterday, but it's relevant because it just helps to test the appellant's thesis. So I spent last night just checking that position, because I said in the provinces at least, you do see telephone numbers on the side. And as it turns out, and I'd forgotten, is that the Department of Transport has published non-statutory guidance on the topic, which I've put in front of your lordships, and it's still current guidance, although it's quite old. And if I can just take you to it, paragraph 38 says the public can often confuse PHVs and taxis, failing to realise that PHVs are not available for immediate hire, and that a PHV driver can't be hailed. But it's important to distinguish between the two types of vehicles, and then possible approaches are given. The first approach is a licence condition that prohibits PHVs from displaying any identification at all, apart from the local authority licence plate or disc. And then it says the plate is a helpful indicator of licence status, and it helps identification if plates are displayed. But requiring some additional clearer form of identification can be seen as best practice. This is for two reasons. First, to ensure a more positive statement that the vehicle can't be hired immediately through the driver, and secondly, because it's quite reasonable and in the interest of the travelling public for a PHV operator to be able to state on the vehicle the contact details for hiring. And then secondly, a licence condition which requires a sign on the vehicle in a specified form. This will be often of a specified size and shape, which identifies the operator with a telephone number for bookings and the local licensing authority, and which also has some words such as pre-booked only. This approach seems the best practice. It identifies the vehicle as private hire and helps to avoid confusion with a taxi, but also gives useful information to the public wishing to make a booking. It's good practice for the vehicle identification of the PHVs to include the contact details of the operator. So what the appellant said yesterday was unlawful applying for hire is in fact described by the department as best practice. I'd also searched as much as I could last night, and to the best of my knowledge, authorities are following this guidance by either requiring or permitting or encouraging such display. I couldn't find any authorities which prohibit it in their licence conditions, standard licence conditions or policies. I should say, for completeness, I add that the government is currently consulting on new guidance replacement to the 2010 guidance, which suggests permitting the operator's name but not contact details. I can't say whether that proposal will survive at the final draft. Time will tell. But for present purposes, the important point is there's no guidance and no case law which says that putting the phone number on a vehicle is illegal. It isn't. And the reason it isn't, to adapt Lord Chief Justice Parker's words, is it's saying you can't just step in and have me without a booking. But if you ring the office, they'll see if they can book you a vehicle, and it might be mine, but it might be somebody else's. And if that's true for a real vehicle, which you can see, then it's also true, we say, for an anonymised log on an app. So that's what I want to say about telephones on the side of vehicles. And then just one other very tiny, tidy up point is that during submissions on Reading Alley, Mr Matthias said, I think that the operator wasn't licensed by Reading. The relevance of that wasn't stated, but I assume it was an attempt to criticise the private hire operator or there is needed to tackle such unlicensed conduct. In fact, as the first line of the head note shows in Reading and Alley, the operator was licensed by Transport for London,
Yes.
as was the car.
Well, Uber London Limited is plainly licensed by Transport for London, but I read the case as suggesting that there was nothing wrong with a vehicle licensed by Uber for London being in Reading.
Yes.
I don't know how far the empire of ULL extends.
Well, I couldn't help you about that, but I can tell you what the law is. Section 75(2) of the Local Government Miscellaneous Provisions Act expressly says that provided the triple lock is in place, the journey may start, proceed through, or end in any district. And ULL was relying on that. ULL, as a matter of commercial compromise, has placed its operation into regions so that drivers, as a matter of fact, don't stray beyond regions. But that's a commercial stroke political decision by ULL. The fact is you can be licensed in Southampton and you can go off and you can take a private hire journey in Berwick, but it's all got to go through the Southampton operator. That's the way the law works. And it's been upheld by the High Court in a number of recent decisions, including in relation to Uber.
So it's where the question of where the operator is located, not where the
car is.
The car is. Yeah.
And I can sidetrack from this, but it's not directly involved. Lord.
Yes.
Thank you.
Thank you very much. Miss Lester.
My Lords, just on the guidelines point, I'm sorry this isn't yet on your bench, but can I please hand up the London equivalent to what you've just been shown?
Yes.
So you'll see this is the Transport for London guidelines for advertising, including on London private hire vehicle signage. And if you look just at paragraph 14, we've only given you the extract. Signs and logos identifying only a licensed London PHV operator and contact telephone number and or website addresses are permitted in one of the following positions. I should say that this version of the guidelines are currently not on the Transport for London website, and I understand that this issue is being currently considered, but that is the current position.
Yes.
In practice, of course, a number of operators don't in fact display their phone number or anything else on the side of the vehicle. And that's mainly due to the fact that drivers can, of course, work for multiple operators. But some do, some don't.
Why is it, perhaps one shouldn't give evidence, but why is it so unusual in London but not elsewhere for private hire vehicles to have a contact phone number? Is it because the drivers tend to be working for more than one?
Exactly, yes. So for smaller operators, they do sometimes have that information.
Yes.
So Transport for London, for whom I appear, as you know, licenses and regulates both the private hire and taxi sectors. Transport for London has two key interests in and concerns on the issue before the court. Its first concern is always trying to maintain public safety. Of course, TfL isn't an advocate either for the private hire or the taxi trade. But as you heard, of course, the purpose of the legislative scheme for both types of trade is public safety, including, crucially, drawing a clear distinction between private hire vehicles and taxis, and ensuring that the public aren't misled into thinking that a vehicle is a taxi when it isn't licensed to ply for hire. And you've heard about the restrictions in the 1998 Act, ensuring that PHVs don't look like taxis for that reason. Its second concern, of course, is clarity. So you heard from Mr. Colvin yesterday the importance for private hire vehicle operators and drivers about the need to be clear, particularly in the context of criminal offences. But of course, this is also crucial from the point of view of a regulator granting licences in this field. And can I just show you parts of the witness statement of Helen Chapman, who's the Director of Licensing, Regulation and Charging at Transport for London. It's at tab 7, page 157 of the supplemental bundle. So if you look first, please, at TfL and its functions on page 159. Obviously, I'm not going to read this whole statement, but you'll see there in paragraph 12 that TfL regulates both the PHV industry and the taxi sector. The licensing regime, Ms. Chapman says, in respect of taxis is different from that in respect of PHVs in several important ways, and she lists a number of them. I'd draw your attention just to the last of those, E. Crucially, for the purposes of applying for hire issue, taxis are entitled to apply for hire, but PHVs are not, and must be pre-booked through a licensed PHV operator. She sets out the separate frameworks, and then the heading at the bottom of the page, the PHV licensing regime and sector. She sets out regulation of the PHV industry, and then at paragraph 20, PHVs must be pre-booked before a passenger commences the journey. This is one of, by no means, the only distinction between private hire vehicles and hackney carriages. And I will show you briefly the key importance of that factor to Transport for London when it's making a decision about whether to license an operator for private hire vehicles. And then over the page, on page 162, paragraph 28, changing modes of PHV service delivery. The business model of many PHV operators involves receiving and accepting bookings by telephone at the operating centre, or prospective hirers attending a booking office, known colloquially as minicab offices, to make a booking in person. She then talks about changing technology in this field, and at the end of that paragraph, as well as providing a telephone number to book services and having a conveniently located minicab office, some PHV operators have also given passengers an option to book via its website and or to download and use an app. In the last 10 years, technology has changed significantly across many sectors, and the taxi and PHV industry are no different. Skipping ahead, some operators give customers an option to book services via a booking form on a website and or to download and use an app in order to book services while maintaining a telephone number and a conveniently located minicab office. And then at paragraph 30, the number of PHV operators that only accept bookings by means of an app. Paragraph 34, Ms. Chapman talks about developments in the position on applying for hire, and above paragraph 41, its approach licensing London PHV operators. She then describes, as the court heard yesterday, that this issue is not new, that there have been abortive attempts at litigation on this issue in the past. But crucially, coming back to Transport for London's need for clarity, she explains that TfL's position is always based on its understanding of the legal position, and could I just ask you to read paragraphs 45 and 46?
Yes.
And then coming on to the position in relation to Free Now's model, and I will show you briefly the TfL decision under review in a moment. If you look, Free Now's model as a heading at the top of page 167, and the key point here is at paragraph 51, the fact that the booking is accepted by Free Now before Free Now assigns the booking to a driver to carry it out is significant from TfL's perspective because it makes clear that the booking is accepted by the operator. And then at the end of that paragraph, importantly, I understand that the app does not provide the ability for passengers and drivers to communicate with each other prior to Free Now accepting the passenger booking. There are other parts of the booking process that, from TfL's perspective, help further to demonstrate that it is the operator that has accepted the booking. So it's obviously crucial for Transport for London to establish the boundary between taxi bookings and private hire vehicle bookings, in particular establishing that there is always a pre-booking by the operator and that the passenger cannot simply hop into the taxi and make a booking direct with the driver.
But is the use of the word allocated justified? Mr. Colvin told us yesterday that Free Now driver app allows drivers to refuse the booking, saying, I don't want to go to Wimbledon or wherever it is. So it may be that the app goes around several drivers.
That's correct, and I'm going to come on to that and show
Right.
you briefly how the app works, but you're right, allocate may not be a completely appropriate word there. But allocate is not meant in the sense of choose a driver and allocate the particular journey to that driver. And then just finally on this statement, could I ask you to read what she says at paragraph 53? So what Ms Chapman says about Transport for London's approach, you will see in the decision under review, which is at tab 20 of the core bundle at page 321. Can I ask you to look at that, please? And there are really two key points from this decision. You'll see as we go through it briefly that the key point is that Free Now demonstrated to TfL that its model ensured that customers could only use a PHV with a pre-booking by the operator, in other words, that this was lawful private hire business, and it ensured that passengers couldn't be confused, that there was a clear distinction between private hire vehicles on the Free Now app on the one hand and taxis on the other hand.
Sorry, why do we get that from page 265?
Sorry, are you in Ms Chapman's statement there?
No, you
No,
said look at tab 20, which I've done.
Do you have, is that page 321?
Who?
In the core bundle.
Ah.
Sorry. Should be the last tab if you have tabs in the core bundle. It's the decision renewing Free Now's license. I'll show you the relevant bits. I was just foreshadowing what the key points are.
325.
Is it?
Page 325.
In mine it's 321. But if it's a decision dated the 3rd of August 2020.
So it's just different on the electronic.
Okay.
Anyway, it begins Michael Stack,
Yes,
interim
okay.
head of licence.
So the background there is set out, which is Transopco's original licence. And then, as you've heard, there was a change which meant that whereas originally this was a taxi app service, it then related to both taxis and private hire vehicles, and that was the context of the renewal decision. If you look at the bottom of page 325 or 321, depending on what you're looking at, the last full paragraph, as part of this renewal applications process, our purpose has been to review the entirety of the licence period to date and confirm that FreeNow continues to be a fit and proper operator, and if licence would continue to comply with the requirements of the Private Hire Vehicles London Act. At the top of the next page, since submitting its renewal application, TfL have liaised with FreeNow regarding all aspects of its renewal proposal. They've also recently moved operating centres following an application to vary the licence. The relevant inspection of the proposed premises was conducted and all was deemed to be satisfactory. Next paragraph, a renewal inspection of FreeNow was conducted and this found them to remain compliant. During the inspection, the compliance team verified that the booking process had not changed and confirmed that other related processes and assurances given by FreeNow were correct, e.g. no evidence was found of a taxi being used to undertake private hire booking. Recommendation at the bottom of the page. Following the review of the submitted application forms, the technical information and the wholesale record and fitness review, I'm content that bookings continue to be accepted by the licensed operator at its proposed operating centre. And you'll recall those as features of the 1998 Act, that bookings are accepted by the operator at the operating centre, and both of those have been checked by TfL. At the end of the next paragraph, with the sentence starting FreeNow sufficiently demonstrated that a driver cannot accept a booking directly from a customer, and that all bookings will be accepted by FreeNow at its registered operating centre. It remains clear that FreeNow, as the operator, will accept the booking and then locate the drivers and vehicles available and allocate jobs accordingly, and I will come on to how that works. But in other words, what Transport for London have been shown is that this is, in the language of the older case law, a pre-booking through a job master, through now an operator, not exhibition and then soliciting a customer to hop in without a pre-booking. And then the next paragraph, last sentence, it's worth noting that FreeNow have indicated that there are no scenarios where they would seek to fulfil a private hire booking with a taxi if the operator is unable to fulfil a confirmed booking. So again, maintaining the clear distinction between taxis and private hire vehicles. Bottom of the page, careful consideration has been given to FreeNow's approach to public safety and delivery in London to date. No significant safety issues. And then on page my 324, which is probably electronic 329, the penultimate paragraph at the end. Sorry to skip around in this, I'm trying to draw out the key points.
Just while we're on page 323, or at least 323 for me,
Yeah.
about halfway down it says drivers available to FreeNow continue to have to agree to be restricted to 10 hours work a day followed by 7-hour mandatory rest period. Does that apply to Hackney carriage drivers as well?
I think the answer is no, but can I check, please?
Yeah.
No. So back to 324, penultimate paragraph at the end. it's important to ensure that we have reassurance around the clear separation of those services. That's the private hire and taxi trades referred to in the sentence before. So this needs to continue to be monitored and ensure that it's being satisfactorily maintained. And then under recommended conditions at the end, we've taken into consideration our broader experience of the private hire trade and advancements of technology which have changed how passengers engage and use services. As the licensing and regulatory authority for taxi and private hire services in London, our priority is public safety. Now you've seen Ms Chapman's statement that TfL has obviously been working on the basis that the Reading and Alley judgment gives it clarity about how to approach app-based booking systems. And you've seen what Ms Chapman says about this. Now, on the alternative tests proposed by UTAG for applying for hire, whether the driver of a car is driving around while being active in the sense of logging onto an app as opposed to doing something different that might be more passive, would we submit create total uncertainty for Transport for London? Mr Colvin talked about uncertain broad criminalisation for PHP drivers. They're told that they can ring up their operators to tell them that they're not free, that they are free, but they can't log on to the app to do the same thing. And uncertainty about how lawful private hire trade might work on UTAG's test. They can't drive the streets, we're told, in busy areas of town in search of custom, but equally they can't dematerialise. So how is this supposed to work as a matter of practice? If they log on to an app, they can log on, I think it was submitted yesterday, if the vehicle is in the garage, but not if it's out on the street outside a driver's home, depending on where that street might be. But the point I want to make is the unworkability of these tests from the point of view of the regulator in charge of both of these schemes. The hallmark of the boundary between applying for hire and not applying for hire has never been whether the driver's conduct is active or passive. And from a regulatory perspective, we submit this is a recipe for uncertainty and regulatory chaos. Whereas the current system is perfectly clear. If an operator is accepting the booking and only then offering the ride to drivers, and there are other clear distinctions between taxis and PHVs to ensure customers are not misled, the regulatory scheme has been working fine. The last point I want to make is to have a look at how the app works to illustrate the points made yesterday, and we submit that when you do, you will see why the Divisional Court in Reading and Alley was right in its analysis. There are a few helpful images in the supplemental bundle, starting at page, what I hope is page 120 of the supplemental. You have that. That should be the first page of the exhibit marked KP1.
Pick-up address 226 Strand.
Yes.
Yes.
So this is what the passenger sees when he or she opens the app. And as you can see, what the passenger can see is that 5 vehicles are in the area. That's the blobs. But obviously they can't identify the vehicle. They can't identify the driver. They can't actually tell if these are PHVs or taxis, and they can't request to book any of these particular vehicles. And at this point, the driver has logged on to the app, and therefore, as canvassed yesterday, they have thereby informed FreeNow that they are working and available for business, in exactly the same way from the driver's perspective that they could have done by phoning into the operator, formerly the job master, and saying, I finished my lunch break, I'm driving down the Strand, I'm available. Of course, it doesn't mean that they wish to take or will accept any particular offered ride. What this is not, by the driver logging on, is communicating to the passenger that his vehicle is free and available to be hired without a pre-booking. Applying for hire. In fact, he isn't communicating anything at all to the passenger. There is no direct communication, and you'll have seen that in TfL's decision, from the driver to the passenger at all.
On your submission, would it make any difference if in this picture there was only one vehicle?
No.
Why not?
Well, that will become obvious in the later images.
All right.
By the time customer decides to order a taxi, any number of those may have accepted other jobs.
Exactly.
And other drivers may have become free, having dropped off.
Correct.
So it's only a
It's a snapshot of who is in the area
might-
at that moment, and that might be 1 or that might be 5. But they may have disappeared or not want to take the job by the time the booking is accepted. And you can see that clearly in the images I'm going to show you. And we say that this illustrates that Lord Justice Flo in the Divisional Court were right to say, in his first reason, you'll recall at paragraph 33, that the depiction of the vehicle on the app simply shows customers whether there are vehicles in the vicinity, and is exactly like the customer ringing the operator and the operator saying there are 5 cars 5 minutes away. Like the vehicles in Reading and Alley, you will recall the findings of fact in the Chief Magistrate's judgment of paragraph 13. None has markings indicating that they are available for hire. They're not in taxi ranks. They have no flashing lights. They're just one of a number of indistinguishable images on the app. They can't be flagged down. Again, findings of fact there that if someone had tried to flag them down, the car would not have taken the passenger for the ride, but would have said they're waiting for a booking through the Free Now or Uber app. In other words, not behaving like a taxi at all. So the next one over the page is at 122, and this you will see, it says at the top, destination entered. So once the destination is entered, and this makes the point that my lord has just made, the vehicle outlines disappear. A fare is quoted if it's a PHV request, and that's a function of regulations requiring that to happen. Now, during this time, the vehicle is waiting for Free Now to accept a booking, and the driver can then decide whether to fulfill it. We'll see that in a moment. If someone approached the vehicle now in the street, the driver again would say, you can't have my vehicle, quoting Lord Justice Flo, but if you register for the Free Now app, he said Uber, and make a booking on it, you will be able to get a vehicle, not necessarily mine. And that is what he meant, paragraphs 38 and 39, about the character of the waiting being entirely different. The vehicle couldn't and didn't solicit custom during that period of waiting. Now, if the customer orders a vehicle, the next slides are black taxis, but if you skip to page 126, KP4, the customer can click at the bottom, order ride now. And at this stage, again, there are no vehicle icons, and there's no question of ordering any particular vehicle. And then, skipping to 139, which is the next relevant image in a different exhibit. Do you have 139? It should be, this time, MZ1, annexed to Mr Zabrocki's statement. Page 139.
We are looking for a driver.
Excuse me.
We are looking for a driver.
Correct.
Yeah.
Free Now has accepted your booking. So that is the operator accepting the booking under Section 2 of the 1998 Act, which says only a licensed operator can accept a private hire booking. That's what Transport for London had to check was happening for Free Now to have its operator's licence. Even at that stage, you'll see no vehicle and no driver has been identified. The vehicle is not being exhibited or projected to the public, soliciting custom, whatever phrase you like. Now, Free Now at that point sends the job to drivers in the area to see if anyone wants the job or not. Now, of course, they can accept it or they can take it. They might have another job on another app or through a phone call or simply don't want to take that job. The passenger has no role, of course, in allocating a vehicle, the booking to a particular driver. And then at that stage, and at that stage only over the page, at paragraph 140, so if a driver takes the job At that point, the driver and the vehicle are identified to the passenger and vice versa. So there's no possibility of a passenger being able to step in and start the journey, the key point of applying for hire, until after the booking has been accepted by the operator. Up until this point, the passenger and driver can't communicate with each other at all. And this, we say, illustrates the second reason, that's the last of the three in my submissions. I've dealt with the first and the third. The second reason given by the Divisional Court in Reading and Alley as to why this model doesn't involve applying for hire. Namely, there is a pre-booking by the customer before the specific vehicle is identified, which is the essence of a private hire booking and not a lawful applying for hire.
That's really, on your submission, that's the crux of this case, isn't it?
Correct, it is. Entirely right.
If one were to vary the facts, just hypothetically, to test the point of principle, I see that this isn't what the facts are, at least on your submission, but just to test the point. If you had a business model which consisted of an app where the customer could see the vehicle in their vicinity, and the business model was, you can book me. Not through an operator, but you can book me.
That would be a different case.
Yeah, you would. I think you would accept that's applying for hire.
Well, and you can see that from TfL's perspective, when being asked to consider an operator license, the considerations they took into account in their decision would be entirely different. They haven't demonstrated there that it's the operator that accepts the booking.
Yeah, but would you accept on that model,
Yes.
or that business model? Would you
Yes.
accept that is applying for hire? So the critical bit of the analysis on your submission is there a requirement of a pre-booking?
Yes.
However short in time it may be, conceptually, that is still
Well, that's
a
what
requirement.
makes it, and that's what makes it private hire, lawful private
I understand
hire.
that. That's
But
why,
it-
speaking for myself, and I know this isn't exactly the reasoning of the Divisional Court, and it may be right and I may be wrong. But speaking for myself, that seems to me to be the crux of the point, and all the talk about exhibition and whether you can see things and so on, not sure is actually central to the analysis, because you can't see it. If you had a business model where all you can see is a little icon wandering around, but the business model is, if you want to book me, you can, then I don't think it would matter that you can't see the vehicle.
I mean, I imagine that Transport for London is not going to want to take a public position on what any other particular model and what any other representation of icons
Yes.
is or isn't applying for hire. But I think what is clear is that the fact that there can be a pre-booking and that this is therefore lawful private hire business is a strong indication that it's highly unlikely to be applying for hire. Now, whether one can play with how much the particular icons on a particular business model tip the balance into and how far exhibition is key, we do say that the Cogley principles are very clear that exhibition is a clear part of the test.
Yes.
And obviously there may be incremental developments along the way where future courts have to test that.
Yes.
But what is clear is that this business model isn't applying.
But it seems to me, at least, and I may be wrong, that the central part of the analysis is really paragraphs 38 and 39 of Lord Justice Flo's reasoning. In other words, what he called the third reason, which is that if you got into the back of the private hire vehicle and said, off we go, the driver would say, no, we don't. You've got to make a pre-booking. You can download the Uber app if you want and make it, but I'm not taking you anywhere.
I mean, it may be, obviously the cases have developed, first of all, pre the private hire trade. And the courts have always considered a number of different factors as either amounting to applying for hire or not, including aspects of exhibition, including flashing lights, are they in the bus lane, and so on. But obviously times have changed, and now there is the very important additional aspect, which is if this is a lawful private hire booking, it's very unlikely, as Mr Colvin said yesterday, to have aspects of applying for hire. And so the pre-booking aspect has been made more important given the legislative scheme for private hire booking.
Yes, I see.
May I take instructions on one point, please?
Yeah.
I had one point to make about costs, and that's it, my lords. So on costs, you've seen what we've said in writing. UTAG, as you've seen, won on one point, the bookings point, and lost on one, the applying for hire point. Didn't get the remedy it sought, namely a quashing. But a couple of points on the point on which UTAG did win, on the bookings issue, the formulation of that issue that succeeded was added by amendment after permission had been refused on the papers following the judgment being handed down in Aslam. And after permission had been granted, Transport for London took no position on that issue. It was neutral on that issue. We took a position only in relation to applying for hire. So, and UTAG's submission on remedy, as I've said, were refused. The other ground for judicial review was dismissed. And in those circumstances, we say, it was well within the discretion of the Divisional Court to make the costs order that it did. Unless I can assist further.
I just noticed this morning that TfL filed a respondent's notice.
Yes.
Which turns on such distinction as there might be between the word exhibited and the phrase on view.
Yes.
Speaking for myself, I can't see what the distinction is, but
it was, well, and that's the point we make in the respondent's notice.
Yeah.
Looking at the Divisional Court judgment, and you'll see this from the respondent's notice, it's for the avoidance of doubt respondent's notice. We thought that there might have been a suggestion that what was being suggested was that the principles in Cogley were not that exhibition meant on view. Insofar as that was being suggested, we've put in all the references to that in our submission being clear. It's no more than that.
thank you very much, Miss Lester.
May it please you, my lords. If I can begin by dealing with a point that my learned friend Miss Lester raised with regard to she referred to the evidence from Miss Chapman's witness statement and from the report by TfL prior to the decision to grant the operator's license to Transopco. That's at the supplementary bundle, page 321. Both of those predated, talking about the position prior to the decision of the Divisional Court below. Now, the Divisional Court below, and this was the basis of its decision on the operator issue, following the decision of the Supreme Court in Uber and Aslam, that there is the dichotomy that operators such as Free Now were seeking to establish between booking or pre-booking and the contract was illusory. And it followed from that it was quite clear on Free Now's terms of business, their terms and conditions, both with customer and with driver, that the only contract was between the driver and the customer. There was no contract between the customer and Free Now. And that was unlawful. That's what the Divisional Court held. Now, that's important. So that the emphasis by this pre-booking, there is in reality no such thing as pre-booking. The notion that there is a pre-booking and then there's something else called the contract is, as I say, illusory. And so, essentially, the position that my learned friend Miss Lester takes now must be that everything that was happening prior to the decision of the Divisional Court below and Free Now altering its terms and conditions so as to remove the assertion that the only contract to exist would be one between the driver and the customer. Everything prior to that change was unlawful operation.
Well, I understand the argument you put below and you're putting hear that that's significant as to costs, but why is it significant on the main issue?
Well, because my learned friend refers to the all that is said about pre-booking by Ms. Chapman and in the report by the officer on the decision as to whether to grant a license to the operator. All those references to the pre-booking as being the crucial test that TfL relied on to determine whether what was being proposed by Freenow was lawful private hire vehicle business. It's now clear that they were entirely wrong about that on the basis of my learned friend's concession.
I thought pre-booking means that the operator and the operator has agreed to the passenger's request to supply a vehicle to take them to Wimbledon or wherever from 226 the Strand. And pre there means pre the vehicle and the passenger meeting. That before, whereas with a black cab there is no pre-booking, simply hailing and the customer steps in. That's what I thought pre-booking meant.
Well, it comes, the importance of this question of booking comes from the Private Hire Vehicles Act. It's at tab 10 in the authorities bundle, page 129. We find it in two places in that act, sections 2 and section 4. Because the act doesn't talk about pre-booking, nor does it talk about contracts. It uses the word bookings. So we see it, section 2.
Sorry, which tab and page?
I'm sorry, it's tab 10. It's the electronic page 129 in the authorities bundle. It's the Private Hire Vehicles London Act 1998. Yes. Requirement for London operators licensed, section 2. No person shall in London make provision for the invitation or acceptance of or accept private hire bookings unless he's the holder of a private hire vehicle operator's license. Subsection 2, a person who makes provision for the invitation or acceptance of a private hire bookings or who accepts such a booking in contravention of this section is guilty of an offence. Now, that is the offence that all the Freenow drivers were committing until the mode of operation was altered following the decision of the Divisional Court below in this case.
Yes.
No mention of pre-booking. There is only a reference to booking, and as the Supreme Court found in Aslam and as the Divisional Court found below, booking means contract for hire. It's the same, there is only one concept.
Yes.
Pre-booking does not come out of the legislation. The other place where we find it is at section 4, obligations of London operators. The holder of a London PHV operator's licence shall not in London accept a private hire booking. And what that means is shall not enter into a contract for hire.
Yes.
So how does that work in the old-fashioned minicab? The minicab driver who rents the radio on the radio circuit.
Yeah.
Gets the call, goes and picks you up.
Yeah.
And at the end of the journey, it's £10, and you pay him £10 in cash.
Yeah.
Your contracts with the minicab drivers.
Is my lord talking about the position that pertained prior to the legislation?
No.
Well, if he is, if it depends. If you made your contract with the driver and paid the driver cash, and he wasn't licensed as an operator, post 1998, then he would be committing an offence.
Well, there we are. Obviously, other courts have determined it. It seems to me that's why it says bookings rather than contract. There we are.
But that's
argument's been had elsewhere.
Yes, I mean, and that's the important, and it's important we're not, as it were, led astray by this concept of pre-book. It was a concept of pre-booking that allowed companies like FreeNow and Uber for many years to get away without assuming any contractual responsibility. Because the notion that they advanced was, oh, when it talks about booking in the Act, it's not talking about any kind of contractual arrangement. That's something else. Well, that's the fallacy that Lord Leggatt laid to rest in Uber and Aslam, and it's what led to the Divisional Court below finding that FreeNow's method of operation was unlawful.
But as far as whether someone's applying for trade or not is concerned, it seems to me that is looking at the mechanics of how somebody ends up riding in a vehicle, rather than at the strict contractual analysis of at what point contract is made and with whom.
I want to come on to that, my lord, because that's and I'm not going to take long because I was a long time on my feet yesterday. But I just thought I had to identify for my lords the fallacy in the logic that we find in Miss Chapman's witness statement and in that report that Miss Lester referred to, and to lay to rest this notion that there is something called pre-booking. There isn't. What matters is the contract, and the contract for hire must be made with the operator. Now, the other dichotomy, which is a false dichotomy in my submission, is this: to say, oh, if the cab is operating pursuant to the Private Hire Vehicles Act, that's to say, it is there is a proper contract for hire with an operator, pursuant to which the driver goes and picks up Mr. Jones, then it can't be plying for hire. That's the false dichotomy. Plying for hire.
Who's saying that?
That is the essence of what my friends are saying. They are saying if the car in question is operating or picking somebody up in accordance with the, as it were, the rules laid down in the Private Hire Vehicles Act, then it's not plying for hire. It may not be, but the important point is that plying for hire is what the vehicle and its driver are doing prior to any contract for hire being arranged. Now, they may not be plying for hire, but in our submission, they could be plying for hire prior to any contract for hire being arranged.
They might be plying for custom.
Yeah.
But that's not the same thing as plying for hire.
With respect, my lord, yes, it is in our submission. It is the same thing. Because, yes, there are four, if this court were to find otherwise, as it's entitled to, but it would be flying in the face of at least four of the authorities that we looked at yesterday, where it's made quite clear that a pre-booking, the fact of a pre-booking, doesn't negate the fact that the vehicle in question may have been plying for hire prior to that contract for hire being arranged. There is a clear statement of that to that effect in Griffin and Gray coaches. Can I take the court very quickly to that, because we didn't look at that case in any detail yesterday. It's an electronic page 226 and tab 19 in the bundle of authorities. If I could take my lords to the judgment of Mr. Justice Avery, electronic page 226, internal page of the report, page 111. if we go a quarter of the way down the right-hand column, Mr Justice Avery's judgment, on the part of the respondents, it was contended that as there had been no waiting for the passengers by the motor coach, but an antecedent contract of carriage in each case, there had been no plying for hire. And it's important to observe that the magistrates in this case expressed their opinion that there had been antecedent contract of carriage within the meaning of the decision in Sales and Lake. And then going down a few lines, that phrase antecedent contract seems to have become a catchword. It misled the justices in this particular case, because in a sense there is an antecedent contract in every obvious case of plying for hire. If a person calls a taxi cab from the rank where it is standing plying for hire, he makes an implied contract before the journey starts that he'll pay the prescribed fare. And a mere statement that there is an implied contract is not inconsistent with there being a plying for hire. And the other case that we also touched on yesterday, but didn't look at in any very great detail, I think was Rose and Welbeck, which is at tab 23 in this bundle. And it's the electronic, if I can take my lords to electronic page 259. There's a reference halfway down the page to Cogley's case. And then below that, they're talking about exhibition there. The fact that if those conditions were proved, a ticket had to be obtained from an office or a booking made other than through the driver was immaterial. And we see exactly the same point emerging from the case of Gilbert and Mackay, which I won't take my lords back to because we did look at that in some detail yesterday. There's also, of course, Cavell and Amos with the reference to the touting. So our submission in summary is that plying for hire, if there be plying for hire, is conduct that is antecedent to any booking arrangement or any contract for hire. And the question is, prior to the booking or prior to the contract for hire, was the vehicle plying for hire? Which we say the question is, was the vehicle exhibiting its availability for hire? Whether by being on view or by availing itself of the services of a tout, or with the driver touting for the vehicle himself, or, as you know, and I'm not going to labour the point because I fear I may have done it to death yesterday, by the driver being with his vehicle out on the streets, driving around or parked up somewhere and opening his app. And
I understand that. Am I being a bit slow, Mr. Matthias? Surely, of course, it's prior to the contract.
Yeah.
I mean, exhibition, not that this is a statute, but suppose that Cogley is right in saying that the essential features are exhibition plus solicitation of custom, leading to a contract.
Yeah.
After the contract has been fulfilled, it's not solicitation, is it? Or sorry, after the contract has been entered into.
No, but then when you're on the journey, you're no longer applying for hire.
Sure.
Yes. So you could, and the point, I think my lord has it exactly, because there cannot, a driver may or may not be applying for hire prior to a contract for hire being made by a customer, whether that contract for hire is made with him or with an operator on his behalf.
On your submission, can there ever be anything that a private hire vehicle can do lawfully?
Oh, yes.
Give me an example, a real-life example of what they can do lawfully, which doesn't constitute applying for hire before the contract is made.
They can sit with their vehicle and wait for the operator to call them up on the phone and say, I have a job, would you like to take it? There's somebody standing outside the High Courts of Justice in the Strand who's waiting for a car, and if you're happy, I'll tell him that you'll be along in 5 minutes.
That's
So
effectively what the app does.
I'm sorry.
Well, my lord, it's the distinction I sought to make yesterday, and I don't know that I can, I don't know I make it any better by repeating. By opening the app, on our submission, that driver is actively displaying his availability for hire. So we looked with my learned friend Miss Lester helpfully took us to those depictions of the let's see, it's in the supplementary bundle at page 120. The only reason those vehicles are there in that picture is because the drivers of those vehicles have opened up the app. They've logged onto the app in order to exhibit their availability. What is that if not a virtual rank?
But if the app didn't show those vehicles, you'd say that it wouldn't be applying for hire.
It would, if the app in summer, the app only, the point about the app is it is a way of advertising availability. So it might say there are 17 vehicles in your vicinity.
Well, that's different, isn't it? Because saying there are a number of vehicles, no one of those vehicles is applying for hire in that situation, I think.
Yes.
That's like a minicab. You ring up the minicab company and they say, well, we've got 17 vehicles in your vicinity.
Yes, because in that case, remember the focus, my lord, must be on the driver and the vehicle. What's the driver doing with the vehicle? Is the driver just sitting passively with the vehicle, waiting for his operator to give him a ring? Or is he working off the app and actively broadcasting?
But when the minicab driver joins the radio circuit, that he's signalling his availability at that point.
Not only to his operator.
So I ask you again, if they didn't show the vehicles on the app, then it wouldn't be applying for hire.
It would be if by opening the app in any way broadcast his availability or her availability to those people with the app.
But it doesn't. It doesn't give a name, a number, or even say that vehicle will be available as and when you make the booking.
Well, my lord, I described that as a virtual rank. It's just the same if one goes to a taxi rank outside King's Cross Station. There's a lot.
In any sense of virtual rank, none of those vehicles are saying as and when you order, I will be available. Well, all that is the broadest depiction of what the current state of the taxi in the area is.
Yes, because each of those represents a vehicle with its driver who's opened the app. That's why they're there.
You were quite categorical yesterday. We had a discussion about this. I asked, was there any difference between the visual depiction of 17 vehicles, heaven forbid, within 200 yards of 226 the Strand, and if this were the app's model, saying there are 17 vehicles within
and I said that would be
of your premises, and you say that is
yes.
They are all the 17 are applying for hire. They are all exhibited by the statement on the app, and the case is no different from the way the app actually works.
Yes.
To show 17 blobs.
Yes. Or if there are 17 little crosses, or any. But that is why the app is so attractive, because it does actively indicate to the customers, look, there are cars around, therefore I will book one. There's the beauty of it.
No, I'm sorry. You were about to draw an analogy with the taxi rank at King's Cross Station.
We don't know. Yes, exactly.
You're saying seeing these 5 vehicles here, you say is a virtual rank, like the actual rank at King's Cross Station. Well, can I just suggest one difference to you?
Lord, yes.
I get into the back of the taxi,
Yes.
in the rank at King's Cross Station.
Yes.
And I say, off we go. And the driver says, yes, we do.
Yes.
Whereas I think you said to me yesterday that if I got into the back seat of a private hire vehicle and I said, off we go, he'll say, no, hang on. You've got to make a booking through the app. That's Lord Justice Flo's reasoning at paragraphs 38 and 39.
But that's
How do you say that that's wrong?
well, because my lord, that is because you're dealing with in this hypothetical case with a driver who has decided that he is only going to conduct his business through the app. So he's advertising his vehicle. Well, it's akin, my lord, to the driver in Rose and Welbeck, who said to the person approaching him, "Well, you phone this number, make the arrangement with my operator, and then we can go. You can't just get into the back." But nonetheless, there's no question he was applying for hire.
But he was speaking direct to the customer, individual driver to individual customer.
I think yes, exactly. In that instance, yes. But it's the same point, my lord, that he's saying. What he is saying is you can't just get in. You can't just get in. You've got to go through a certain arrangement with my operator. And it's precisely the same, of course, with somebody, the hypothetical driver that my Lord Justice Singh referred to, who said, you can't get in, you've got to book me through the app.
If we break down what is really being said here by that depiction, it is not that those vehicles are not saying to the customer, I am available to take you. What it is that the Free Now are saying to you, those are vehicles that are telling us that they may be available when you press order now to consider whether or not to take your journey. And that's the actual analysis, isn't it, of what it's telling you?
Well, with respect, my lord, I suspect that's not how the customer would view it, and I suspect that's not how the driver would view it.
Never mind how anyone views it. That's the position, isn't it?
No. With respect, by opening the app, the driver he's concerned with telling the travelling public that he's available for hire. That's his concern. And the customer opening the app is concerned to see that there are vehicles available in the vicinity.
Yes,
so that
I appreciate what the driver may hope happens, and what the customer hope happens, but the actual mechanics here, which is what we're talking about, isn't it? The mechanics are that Free Now is saying to the customer, these are drivers who are telling us that they are, in broad terms, available. And as and when you order a taxi, we will then contact those or any others who may be available at that time, which may or may not include these 5, and they will then decide whether or not they do or do not wish to accept your booking.
I think what my lord is talking about is the mechanics of the contract for hire.
No, I'm talking about what the app is saying to the customer is the position. I think anyone who uses these apps knows that the chances of you ending up in one of the taxis depicted on here are very variable, because things are in a completely fluid state, and all that's being said here is that if you book, we will then ask these and other drivers whether or not they will accept your booking, and they may not. One has experiences, particularly at the moment, that you look at a screen and there seem to be lots of cars there, and when you place the booking, you're saying, searching. Sorry, we can't find a car. So the idea that seeing these little blobs on on the screen actually means that people are offering to take you now, it is in practice completely illusory.
But I do with respect, my lord, maintain that what you're focusing on, you're, as it were, I say this with every respect, looking at it down the wrong end of the telescope. You're rather than asking the question of what is the driver and his vehicle doing, are they seeking and achieving the exhibition of their vehicle as being one that is available for hire? That's all. That's all that's required for applying for hire. And an undue focus on the mechanics of the booking arrangement or the contract for hire. If we focus on that, then we're missing that is not the crucial question. That can be achieved in all sorts of ways, and it can be achieved for the benefit of a driver who is not applying for hire, or it can be achieved for the benefit of a driver who is applying for hire. The fact that the operator is conducting private hire vehicle business in accordance with the legislation does not mean that all the drivers for whom he is or she arranging the contract were not, prior to that point in time, applying for hire.
I think your answer to, and look, my Lord Justice Singh asked you, is there anything that PHV drivers can lawfully do? And you gave an answer from, if I may call it, the pre-app days, the traditional minicab. If I can rephrase my Lord's question to being, is there anything that PHV drivers can lawfully do using an app? I think your answer is no.
Yes, it is. It is. And it is quite interesting that I think my Lord Justice Phillips, at an early stage in my submissions yesterday, spoke about there being three models. There was the black cab, the traditional private hire vehicle, and then the app-based private hire vehicle, that app-type operation. And that, of course, does rather shine something of a light on the fact that by the use of the app, private hire vehicles are doing something that is quite apart from private hire vehicles operating in what we would say is a lawful way. It's something different. But of course, there are only two categories of hire vehicles in London. There's the black cab, the hackney carriage, and there's the private hire vehicle. There isn't a third category.
Yeah. Well, you can say that when Free Now was Halo with only black cabs, it was certainly presented as though this was the way that you hailed a black cab in the modern age. You, rather than stepping onto the street, you flagged it down the app.
Yes.
And that's a perfectly fair point.
Yes. Lords, unless can I?
Yes, of course you can.
Thank you, my lords. I've no further submissions unless I can give any further assistance.
Thank you very much, Mr Mathias.
Thank you, Mom.
We're grateful to all counsel, not only the leaders who spoke, but the juniors who didn't. My apologies to them for not calling on them in the bold manner to follow, in which case we will, of course, reserve judgment. We'll send out a draft in the usual way. If this hasn't been done already, would junior counsel on each team send my clerk contact details for people to be sent the judgment in draft, preferably leading counsel, junior counsel, and 2 individuals at each instructing firm in order to comply with all the requirements of the Master of the Rolls in Counsel General for Wales and so forth.
My lord, yes.
And then when the judgment is sent out, it will, as you all well know, not be for re-argument, but for correction of typos and manifest factual errors and so forth. Thank you all very much.
Thank you, my lord.
What, right?